When a major construction project grinds to a halt, the financial bleeding begins immediately. Every day of delay drains resources and fractures relationships. To stop that bleeding, parties often bypass the public court system entirely and opt for arbitration. They want a private, binding, and enforceable resolution to their conflict. The final award carries the full authority of a court judgment. It functions as a definitive legal command, allowing the prevailing party to move toward collecting what they are owed. With the signature of the arbitrators, the dispute moves out of the realm of private negotiation and into a formalized legal record. This creates a new status quo that the law is inherently designed to protect. To carry that weight, an award must meet strict international standards. It must clearly identify the parties, confirm jurisdiction, establish the facts, detail the legal reasoning, and state a definitive decision. Once the document is signed, a strict legal rule takes over, functus officio. The tribunal's mandate completely and instantly ends. The arbitrators step down. A legally compliant award extinguishes the original cause of action, stripping the tribunal of any power to revisit the merits of the case. Large construction disputes can take months or years to reach that final stage, but tribunals possess flexible, binding tools to manage specific phases of a conflict long before the final award is drafted. If urgent action is needed, they can issue an interim award. This is designed to preserve the status quo, protect critical evidence on site, or secure costs while the rest of the case proceeds. Alternatively, they might issue a partial award to divide a complex timeline. For example, this diagram shows how a tribunal might rule on who is legally at fault, liability, before anyone spends massive amounts of time and money hiring experts to calculate the exact damages. These awards create immediate, enforceable obligations on specific issues, while the rest of the case remains in progress. Tribunals also have mechanisms for handling parties who refuse to cooperate. If a respondent completely ignores the proceedings, fails to appear, or refuses to submit evidence, the tribunal can trigger a default award. Walking away doesn't hand the active party an automatic win. They still have to prove their case with evidence, and the tribunal is still required to issue a fully reasoned, formal decision. On the other end of the spectrum, opposing parties will sometimes reach a private settlement mid-arbitration. When that happens, they can submit their agreement to the tribunal to be recorded as a consent award. This step is crucial. Recording a settlement as a consent award transforms a private contract into a formal judgment, granting it international enforcement power under the New York Convention. Once a final award is issued, the losing party might try to challenge it in a national court. But taking an award to a judge is not an appeal. The court will not reinterpret the underlying contract or reevaluate the facts of the dispute. Judges operate on narrow grounds. Arguments about credibility bounce off. The filter only passes procedural defects, invalid agreements, lack of notice, or tribunals exceeding their authority. The only other exception is public policy, where enforcing breaches basic standards of justice. Those valid legal challenges are completely different from a party simply disagreeing with an expert witness or complaining that the damages awarded are too high. In the arbitration system, courts act exclusively as jurisdictional border guards, ensuring basic fairness. They are not appellate bodies meant to correct bad math. If a losing party does decide to fight, they have two distinct geographic strategies to choose from: the proactive act of setting aside an award and the defensive act of resisting enforcement. Setting aside an award is a direct attack. This challenge can only be launched at the specific geographical and legal seat of the arbitration, the country whose laws govern the proceedings. Resisting enforcement, on the other hand, is a localized defense mechanism. It is used only in the specific jurisdiction where the winning party is actively attempting to seize physical assets or collect money. For construction professionals, the practical philosophy is clear. You have to argue the facts exhaustively during the arbitration phase. Once that phase ends, the resulting award is legally presumed to be permanently valid. Respecting the finality of the award is the foundation of the entire dispute resolution system. Unless a severe, recognized legal defect exists, parties are required to accept the outcome and move on.